people are entitled by law to enjoy their own dwelling house without any undue interference from outside. If you are troubled by noise, whether it be noise from a neighbouring house, whether it be from a house that's let in your vicinity, whether it be from a local authority house, or even from a nearby business premises, you have a remedy. And if you proceed properly, and fulfill all the steps, usually you can get your problem solved. There are three things you have to do basically if you're troubled. Let's take it that you're living in a private house and there's noise or interference from a private house next door or in your vicinity. There are three things you must do. First of all, you must complain. Secondly, you must record. You must record the circumstances and the times at which the interference occurs. And thirdly, you must gather evidence. Now, what do I mean by that? When I talk about complain, I mean the first thing you do is you complain to the house owner. Now, you can do that verbally or in writing. It's better to do it in writing because then you have a copy of it as proof later on that you actually made the complaint. If you find it uncomfortable to do so in the first instance in writing, if you prefer to have a chat with your neighbour, that's fine. But just record the time and date that chat occurred and what transpired. If the initial chat with the neighbour doesn't work, then you do a formal letter advising the neighbour of your rights to seek a noise enforcement order from the district court. Now, it would be better if you'd send a registered copy. In this case, you have proof of the fact that you sent the letter, and there's also a standard way of doing these letters. And if anybody needs any advice on how you should word the letter, etc., feel free to contact me. The third thing is, in case there is subsequently a hearing about this matter, or in case you want to prove your case, you record the instances, the times, the places, etc., and the times at which the noises occurred, and also, and this is very important, what effect they had. For example, you could have recorded that noise occurred shouting and yelling, or maybe loud music or something at 12 o'clock, between 12 o'clock at night and 2 o'clock in the morning. It woke your children from their sleep and it affected their schoolwork the following day. It also kept yourself and your wife awake, or yourself and your husband awake, and that you were unable to function properly the following day. Sometimes it can affect elderly people who are ill and who need their sleep, etc. So it's very important to record all that. Now, sometimes people record noise on a mobile phone, and that's not a bad idea because there's no specific level of noise above which a person can't go. The court has to decide, or the authority has to decide. Each individual case has to be decided on its own facts. Sometimes people get in an engineer to record noise. Now, of course, that can be expensive, but sometimes it's necessary if the situation is bad enough. But the important thing is that, at a very minimum, if you're not using any recording devices, etc., at a very minimum, you should keep a record of every instance of noise and how it affected you. It would be very useful, of course, and usually this doesn't happen because people don't want to get involved, but if you could bring in a third party, say a neighbour, a friend, who would be a witness to what happened, that would also be very useful. But they're the important three things anyway: to complain, record, and gather evidence. Now, what happens if you make that complaint, if you send that formal letter, and there's still no response? Well, in that case, you can seek a noise enforcement order from the district court. Now, this isn't the same as employing a solicitor, going down to court and incurring all those costs. You simply fill out a form and pay a very small fee. It used to be €15, I think it still is. You fill out a form, goes to the district court. You don't need a solicitor. There's nothing to stop you getting a solicitor, and you may need a solicitor for cross-examination purposes and all that, but you simply fill the form and the case will come up in due course. Now, sometimes we'll say the person who's making the noise, the person who you're complaining about, doesn't turn up at all, and if he doesn't turn up, generally speaking, the district court will issue a noise enforcement order. Now, that can consist of controlling the noise, keeping it down to certain levels, making an order that the activity causing the noise can only occur at certain times, etc. There's a whole variety of things, or they can order the noise to be stopped entirely. Now, many people ask, what happens if the court issues such an order and the noise still doesn't stop? well, well, that is a criminal offence. It's a criminal offence to disobey a court order, and the person who is making the noise can be prosecuted and suffer quite severe penalties. Now, before that happens, if a noise enforcement order is made and nothing is happening, the best thing to do is you don't prosecute yourself, because you can't take a criminal case, only the state can do that. You go back to the local authority and they will advise you on the next steps as regards having that person prosecuted. Sometimes the court will adjourn the case to give people a chance to settle their differences and maybe come to an amicable agreement. But again, if that doesn't happen, you have to proceed as I indicated. Now, of course, there are different remedies depending also on, I'm referring here to a private house. And if you have a house which is let and you want to complain about noise, you complain both to the landlord and to the tenants who are causing the noise. And ultimately the noise enforcement order you will be seeking will be against the landlord for his failure to control the noise. Local authority houses, if the noise is coming from a local authority house, you can of course also complain to the local authority. There is a section within the local authority whereby you can complain about this disturbance. So they will call in the tenants and have a chat with them, and they have various powers about how to deal with them if the noise doesn't subside. But as I say, if the situation continues, you can go along the other path that I indicated anyway. The other thing to remember is that in the case of those multi-storey apartments, multi-flat complexes, as well as complaining to the tenant and the landlord, if you know who the landlord is, you also make a complaint to the management company of the apartments. That's part of the procedure. So that just outlines the general rights you have. Now, they may take a while. For example, you make the complaint, you give a person a reasonable time to answer the complaint, then you do the formal letter. If that's not responded to, then you fill the form and go to the district court and get your order. Now, all these things take a bit of time, of course, but at the end of the day, if they will succeed, you will succeed if the noise is excessive, and you have to go the full distance. Now, if, as I said, the part of the district court's power is to order a person to desist, to stop the noise. Sometimes people feel seriously enough about the matter that they want to get an injunction, a legal injunction. Now, if they're looking for a legal injunction against a person, they have to go as far as the circuit court, which is, of course, would be going the normal way. It's not just like applying to the district court for a noise enforcement order. You'd have to get lawyers, etc., and that can be an expensive process. So basically, I'm just outlining the thing in bare detail here. If anybody has any specific problems or queries about how to draft the letters of complaint, or how to go about seeking a noise enforcement order, or what do you do if one has been given and it's not been obeyed, please feel free to contact me, and I'll be delighted to help you in any way I can.